Hello, everybody. Good morning. I'm very honored that I was invited to speak here to this conference, with this quite important conference, I think, about prosecution of international core crimes in domestic courts. First of all, I was introduced. Thank you so much. My name is Ritscher. And I have to make a disclaimer, of course. Today, I do not speak in the capacity as former head of the German War Crimes Unit, as far as I'm not longer head of the War Crimes Unit. And I do not speak in my capacity of head of unit. I'm just making some remarks on my own as Christian Ritscher from my experience that I got over the years. And as I became head of UNITAD a fortnight ago, 2 weeks ago, unfortunately, I don't have an elaborated speech. I just can give you some thoughts, what I have concerning the concept of cumulative prosecution of foreign terrorist fighters and others, according to the German law. First of all, I wanted to introduce you to the German law in order to let you understand why we are doing what we are doing. In Germany, the Code of Crimes Against International Law came into action in 2002, one day before the Rome Statute. Genocide, crimes against humanity, and war crimes were introduced in a separate code, the German Code of Crimes Against International Law. It was not introduced in the ordinary criminal code, but it's a separate code, very small one, consisting of 15 sections. And the substantive law within this Code of Crimes Against International Law is more or less a mirror of the substantive law of the crimes described in the Rome Statute. Before, we had only one international crime codified in the ordinary Code of Crimes. That was the genocide from the 50s on, after the Genocide Convention. But war crimes and crimes against humanity were not codified as such in German legislation. One special aspect in the German Code of Crimes Against International Law is in Section 1, the universal jurisdiction. And it's a pure universal jurisdiction. That means German law is applicable regardless if there is any link to Germany at all. Regarding the crimes of genocide, crimes against humanity, and the war crimes. In 2017, the crime of aggression was added to this code, but there is no universal jurisdiction, and as there is no international customary law on the crime of aggression. The impact behind the universal jurisdiction is, of course, that it is, well, at least concerning to our legislation, that it is international customary law that these crimes, genocide, crimes against humanity, and war crimes, are customary international law and shall be punished everywhere, regardless where they were committed. And that's why the German substantive law is applicable everywhere on the world. Okay, that's it. That's the international crimes side, and on the other side, of course, we have counterterrorism counterterrorism law in the ordinary criminal code, in section 125A and B of the German Criminal Code. This is a membership or founding of a terrorist organization and aiding and abetting to a terrorist organization. That is described here in this code. And what is most interesting in this law, the most interesting thing, I think, is that how this is definite, or what is the definition of a terrorist organization. Under German substantive criminal law, there is no such thing as a referral to a blacklist or whatever, listing of terrorist organizations, but there's a definition within the law what a terrorist organization is. I think this is very reasonable, and in the end, the result is that the justice says what a terrorist organization is, and not the politicians or the administration, because it's so to say, set within the law what a terrorist organization is. A terrorist organization is, according to the German law, an organization which with a purpose to commit certain crimes that are named in the law, enumerated in detail. Crimes mentioned in this enumeration are, for example, murder, kidnapping, and international crimes. Genocide, crimes against humanity, and war crimes are named within the law in section 120A of the German Code of Crimes. So to say in the law, there is an interconnection, yeah, of international crimes and counterterrorism. It is, so to say, intended by the substantive law that a cumulative prosecution shall occur. And so, in other words, an organization that is geared to commit international crimes is a terrorist one under the German law. It is, as I said, within the competence of the justice system to determine the nature of an organization as a terrorist one. Another thing, as I mentioned, there is no administrative act needed except for one constellation. If the organization itself is located not within the EU, but outside the EU, the competent Ministry of Justice, the Federal Ministry of Justice, has to authorize the organization, the investigation against this organization, but only with regards to the counterterrorism aspects. Yeah? We can investigate regardless if this is within the EU or outside the EU on the international criminal law aspects. But if you want to have an investigation against this organization or its members, then you need an authorization from the Ministry of Justice. So there is a political component within that, but only with a view on the counterterrorism aspect. The reason behind this is that that the willing of the legislative was to have no political impact on investigations for international war crimes. Okay, this is the law in Germany. Now I come to how the law is applied. First problem in practical is that the counterterrorism law only applies on non-state actors in armed conflicts. We had several occasions to discuss if we could apply counterterrorism law, that means membership in a terrorist organization, even on national armies. I'm sure the law was not designed for using against national armies. The German parliament didn't think about Syrian army when they created the counterterrorism law. Nevertheless, one could think about that, but up to now there is no example of investigations against national actors in a non-state, non-international armed conflict against a national army. We have the problem that of the damage right. Yeah, the damage right is on the national side, not on the state side, not on the non-state actor side. And there's no decision yet from the Federal Court of Justice on this topic. So that means all the examples we have up to now are concerning non-state actors in a non-international armed conflict. The first cumulative prosecution we had in Germany was the so-called FDLR case against Ignaz M. and Straton M. in 2011. The charges were war crimes, crimes against humanity, and leadership in a terrorist organization. Ignaz M. was the president, and Straton M. was the vice president of FDLR, a DRC, a Democratic Republic of the Congo-based militia of Rwandan origin, who came to the eastern parts of Congo in the aftermath of the genocide. A Hutu militia who tried to get back to Rwanda in the first years, and later on, more or less, established parallel structures in the eastern provinces of the DRC, terrorizing the civilians living there. And what was quite special was that these two guys, the two defendants, were living in Germany. Both came to Germany as students and lived in Germany. Fun fact aside, the vice president was even employed in the state ministry for justice of Baden-Württemberg as an IT expert. Nevertheless, both engaged in these in the civil war in the DRC during the 2000s, and they did it remotely with the then used modern technology like emails and over Thuraya satellite phones. And well, they were quite at least Ignas was quite in contact on a regular basis with the militia on the ground. He was unemployed and was completely devoted to this. Okay, and they were made responsible for acts of war crimes and crimes against humanity in 2008 and 2009 in the Kivu region of the Democratic Republic of the Congo. The trial lasted more than 4 years. Evidence was taken regarding all charges, including, of course, crimes against humanity, war crimes, and membership in a terrorist organization. We had a lot of intercepts of telecommunication. We had emails. We had a lot of witnesses who came from Rwanda, or even from Rwanda, from the DRC. We had video conference interviews to unknown places where the witnesses were located during the interview, aside with a German lawyer who described them what will happen, what was quite a challenge for everyone. We had expert witnesses, we had documents. In the end, the judgment was handed down in 2015 in September, as far as I remember. And it said for both leadership in a terrorist organization, for Ignas M, war crimes or aiding and abetting to war crimes, but not crimes against humanity. As the verdict was not very convincing, we appealed against this verdict, and on appeal, the verdict against Straighten M was upheld by the Federal Court of Justice. He got 8 years for leadership in a terrorist organization, and the judgment against regarding Ignas M was reversed, and a new trial was ordered by the Federal Court of Justice and was even scheduled by the higher regional court in Stuttgart, which was the competent court, but he passed away in detention. So before the second trial started. And here, nevertheless, though the judgment did not become final at least against Ignas Movanashiaka, it was the first judgment on cumulative charges, and though the trial was extremely challenging, it was in the end, at least from my point of view, successful, because it proved that it is possible to have cumulative charges in concerning such a situation as a armed conflict, non-international armed conflict, even in a very remote country from German perspective. It was clearly proved that the FDLR was a terrorist organization, and it was proved that it committed war crimes, international crimes, as part of its strategy. This was, the letter was, so to say, an integrated part of the verdict against Straighten M, who was only he got only a membership in a terrorist organization, but he was only convicted for membership in a terrorist organization. But within this, saying this, the court stated that the organization is a terrorist one because it committed war crimes. Okay. Here in this case, we could see an advantage of the cumulative prosecution, because if one could not prove the involvement in international crimes, at least you have the membership, as we had with Straighten M. During the trial, we found that his relation to the militia in the DRC was a quite distant one. He was only in communication with Ignaz M. and not direct communication to the militia soldiers in the DRC. So we dropped the charges of international crimes and upheld only membership in a terrorist organization. This is, I think, yeah, the right decision. And now, well, he got these 8 years now. Okay, after this trial, things developed further on, and the focus shifted towards east, to the Middle East, or Near East, Syria, and mostly Iraq. The first case of cumulative prosecution on this was the case of Abdel Karim E., a classical foreign fighter coming from Germany, maybe with, I think, with grandparents were from Morocco or Tunisia or something like this, from Northern Africa, but he was a German citizen. He was even a soldier in the German Bundeswehr for some time. And then he decided, well, to become a strict Muslim. And he went to Syria in order to fight for ISIS. And when he came back, he was arrested, and we had enough evidence to prosecute him for degrading treatment of a person protected under international humanitarian law, according to Section 8, Paragraph 1, Number 9 of the German Code of Crimes Against International Law, and of membership in ISIL. There on his smartphone, we found several videos showing him and together with other ISIL militiamen brutally destroying a corpse of a Syrian officer, shooting at him and spitting on him and all these things. And this was, I think, as far as I remember, even shown over social media. So the first charges were degrading treatment of a person protected by international humanitarian law. He was sentenced, I think, to 8 years and 5 months or something like this, but he got a second trial and a second prosecution and a second trial for torture. There was another video found on a smartphone showing him, taking the video of torturing of a militiaman, of another militia, not a Syrian army soldier, but a member of another militia, rivals of ISIL. And for this, he got some more years. So all in all, he received 10 years, what he's serving at the moment. This was the first trial concerning the situation in Syria with cumulative charges. And interesting is the first case, the first trial was a prosecution of the Counterterrorism Department, who turned to us, the International Criminal Law section in the Office of the Federal Prosecutor General, in order to help them with the charges of international criminal law. And the second one was only for us, was dealt with within the unit of the international, of my colleagues of the Department of International Criminal Law. So this is something what is going on until now. These cases are shifting between the counterterrorism and the international criminal law, depending on mostly who got first hands on the case. Yeah. So sometimes it's by accident who is prosecuting, and sometimes where's the focus? Yeah, is it about international crimes, or is it about counterterrorism? The next case we had in our in my former unit is the case of Abbas R and Raad A, two Iraqi men, a father and son. They came to Germany as refugees, classical refugees, in 2015 or 16 or something like this. And the charges were membership in ISIL and being involved in the extra-legal killing of a captured person protected under international humanitarian law. The proof was a propaganda video of ISIL where the son was to be seen during an execution of a Iraqi police officer. He was captured and was brought to a place and with a lot of people standing there, and he was killed publicly, shot in the head, and this is all to be seen on the video, quite cruel one. And you see the son, the younger of the defendants, shouting at him, insulting him, and spitting on him seconds before he was shot. The father was not to be seen because the ones who killed him were masked. But we had a lot of witnesses proving that he was involved in this killing, and he was one of the gunmen standing next to them, and he was shooting at him, or at least was within the killing. It was a very difficult case. The defendants were quite aggressive. My colleague was insulted several times during the case, during the trial, which lasted more than 2 years. Even the defense lawyers were trying to sabotage the whole trial. But in the end, after more than 2 years, the verdict was handed down, and the father got lifetime for membership in a terrorist organization, ISIL, and killing of a person protected under international humanitarian law and murder. And the son got under youth law, youth criminal law, he got 5 years, 10 months for degrading treatment and aiding and abetting of the killing. This verdict is not final yet. It's on appeal, but I'm quite confident that it will be upheld by the German Federal Court of Justice. This was the second important approach to this cumulative prosecution. The next phenomenon was a one of what is still going on. These are the so-called ISIS spouses. Women who came to Germany, came from Germany to Syria or Iraq, married an ISIS fighter, lived there, and were mostly just the spouses having children, living there in the ISIL region. The German Federal Court held that the mere housekeeping is not an act of membership in a terrorist organization. The question was what to do with these returnees, and ask the international criminal law prosecutors. We found that we developed the strategy of prosecution for charges of pillaging, because most of them lived in houses and apartments of people who were killed before by ISIL fighters, and then they moved in and they lived there. And this was an act of pillaging according to Section 9 of the German Code. And in the result of that is that this act of pillaging is an act of membership. So again, we could prosecute them, and there were several trials against ISIL spouses because of that. In addition, we had other crimes which were added, like enlisting of the own children by sending them to paramilitary training camps, and child negligence, of course, and most recently and very important were added the enslavement of Yazidi women, mostly for housekeeping, but even aiding and abetting of rape and sexual violence by the spouse's husbands. So this still continues. We have charges of enslavement, of persecution, of torture, and even of killing, like the case of Jennifer W., what is still going on in Munich. The verdict will be handed down later on this year, maybe in October or November. Most prominent case at the moment in the cumulative prosecution is the case of Taha al-Jay, the husband of Jennifer W., what is going on in Frankfurt at the moment because of the killing of a Yazidi child as a war crime and a crime of humanity. And that's most important, and as an act of genocide. This is the first time that an ISIL fighter is in court in trial because of genocide against the Yazidi community. This judgment will be delivered in November, probably. So, in fact, the cumulative prosecution are the standard charges for ISIL-related suspects now. It's not only for ISIL members, but even for other non-state actors. The cumulative prosecution, from our point of view, fulfills the requirements of ensuring the full criminal responsibility. Yeah? It shows the full picture. Charges of membership in an organization, terrorist one or whatever, is a quite abstract, charges. If you want to deliver justice, especially to the victims of mass atrocities, you need to name the crimes for what they are, and not just this abstract membership thing. With this, I quoted the fundamental report on cumulative prosecution edited by the Genocide Network Secretariat. Matthias is with us to promote this legal tool. I strongly recommend this. This is public and can be read on the website. Am I right, Matthias? European countries like the Netherlands, Hungary, Sweden, France, and Finland developed jurisprudence on this, and international organizations like the UN entities IIIM and UNITAD provide assistance and evidence to national prosecution and courts. And I'm deeply convinced that the strategy of cumulative prosecution is an appropriate answer to mass atrocities committed against civilians and persons protected under international humanitarian law by organized non-state actors. Well, international crimes as a result are described in the Rome Statute, as described in the Rome Statute, are, at least from my point of view, terror to the utmost. They are terror to the utmost. Why should we not punish them like this? Thank you.